Good afternoon, everyone. Amy, can you give me a thumbs up if you're recording?
Alan, it's recording.
Okay, thanks. We'll give it about one more minute and then get started. All right, we'll go ahead and get started. Hello, good afternoon. On behalf of the Oregon Project Management Advisory Board, welcome to our Project Management User Group presentation of the month. My name is Alan Thompson. I'll be facilitating our meeting today. We'd like to start with a few housekeeping items. As you may have noticed, this meeting is being recorded, so please mute your phone or PC if not speaking to help reduce any background noise. If you are not speaking, you're encouraged to remain off camera. A link to this meeting resources will be shared shortly after today's session and posted on the DAS YouTube channel and the OPMAB website. If you have any questions, digitally raise your hand or place questions in the chat, and we'll answer them throughout the presentation. If you're looking for two new board members for the OPMAB, a link to becoming a member page will be posted in the chat. Let me do that now. And the planning team is also looking for a new member. Please contact me if you are interested. So also, if you're interested in business analyst procedures, the Business Analyst Networking Group meets the third Wednesday during months in which the PMUG does not meet. They're also looking for a new planning team member. For more information, visit the BANG website, Business Analyst Networking Group, or BANG, posted in the chat. And let me put that in there as well. You're welcome to share with your colleagues and encouraged to spread the word on our PMUG meetings. They're normally held on Wednesdays, but we're holding it on Friday today. I'm pleased to host the session presented by Patrick Flanagan of the Oregon Legislative Commission on Indian Services. Patrick has served as the Executive Director of the Commission on Indian Services since June of 2021. He has spent the previous 11 years as a Senior Assistant Attorney General at the Oregon Department of Justice, where he supervised the Environmental and Cultural Resources Enforcement Unit, a program dedicated to the prosecution of environmental and cultural resource-based crimes. Is Patrick here? I just want to make sure. And yes, he is. So please take it away, Patrick.
Good afternoon. Thanks, everyone.
Thanks for joining on a beautiful Friday afternoon. I suspect there's a lot of other places that you all would like to be, but hopefully this is useful for you and informative, and I'm going to give it my best shot to make it so. Um, I do want to start by saying, of course, as the director of the Commission on Indian Services, obviously, I have a direct connection to the tribes and leadership of the tribes, and we'll talk about the composition of the commission here shortly. But it is important to remember that I am just the director of that commission. I don't speak for the tribes. I don't speak on behalf of the tribes. The best I can do is hope to offer some guidance here for you all based upon that relationship that I have with the tribes and my personal experience and conversations not only with tribal leadership, but also with some of the elders and tribal members, tribal staff, folks of that nature. So, um, my bit of housekeeping is just that as I start to share my screen, I won't really be able to see the chat very well. If anyone has any questions at any point in time, please feel free to just raise your hand and hopefully somebody can monitor that for me and let me know. I'm happy to field questions at any point in time throughout the presentation. Go ahead and get started. Let me see if I can share my screen here. There, I'm hoping that you all are seeing my screen at this point. And just with some fundamental concepts here, I've just kind of have this slide in as a placeholder because I feel like, well, first of all, I recognize this is a very diverse group of people. A lot of different agencies represented, a lot of different responsibilities for each of you. And so in some ways, it's a difficult presentation because of the breadth. But that also means I kind of need to keep this at a 30,000 foot level so that I can make sure that it has that broad applicability. My experience over the last couple of years has been that we really have to start with some foundational concepts just to make sure that we're coming from the same place and the same base understanding. And really, when it comes to working with tribes and understanding what the expectations are regarding consultation, we kind of need to take a look at the tribes themselves, the history of the tribes here in Oregon, and recognize how significant the paradigm shift is when we start talking about tribes in order to get to that understanding of consultation. With that said, tribes obviously were present before Oregon was Oregon, before most of us. I don't know the population here for the presentation, but absent having tribal members in this group, tribes were here before any of us were or our ancestors were. With that westward expansion, which many of us know as manifest destiny, there was an inherent clash of two conflicting paradigms. What one population was seeing as manifest destiny, land of opportunity, westward expansion, unlimited bounds. The other population experienced as genocide. And that's kind of the place that we have to start from with that paradigm shift. And we need to begin to understand that other perspective, the tribal perspective, and appreciate that other perspective if we hope to understand what the tribes expect when it comes to consultation. That said, what the tribes expect, there is no such thing as the tribal perspective, which many of you know and have heard before. And I put this slide up here just as an example. When I first came into this position a little bit over 3 years ago, or right around 3 years ago now, I kind of decided to take a look at what's been sitting on the shelf, so to speak. What sort of tasks have been hanging out there that have been left hanging and we haven't been able to get a resolution to them. And one of those was development of land acknowledgement guidance. State agencies were asking for some sort of guidance document from the Commission on Indian Services as to what should be done regarding land acknowledgements. And I think most, if not all of you, are familiar with the concept of a land acknowledgement. But agencies didn't know when it was appropriate to provide a land acknowledgement, how it should be given, what should be said. So they were looking for some sort of guidance from the commission. And that had been left unanswered. And frankly, I think it was because it was a difficult objective and a difficult result to achieve. As part of that, effort, I kind of reached out to each of the tribes and met with tribal representatives, went to tribal lands and met frequently with tribal chairs and other staff members to get an understanding. And what was interesting was I had developed a guidance document that provided some suggestions on how to give a land acknowledgement, when to give it, who should give it, that kind of thing. And one of the last tribes that I visited with was the Klamath tribes. Now, I had heard already from some individuals that land acknowledgements were a good thing. So, for example, with the Coquel and one of the tribal representatives at Coquel, uh, it was said that land acknowledgements were a good place to start. They're a good beginning and they're useful for that purpose. But when I was down visiting with the Klamath tribes, I was talking to the chair at the time, Chair Gentry, and he explained to me that land acknowledgements actually can be really hurtful because all we're doing is reminding the tribes of what was taken from them in the past. There was an article that was written in the Atlantic that was probably one of the more, I would say, blunt ways of describing it, but as they said, it's like a thief who stole your jewels and decades later decides to write you a note or a letter and say, hey, just wanted to let you know I'm the one who took your jewels. I have no intention of giving them back. So for whatever it's worth, just know that I'm acknowledging that I took them from you and use that for whatever you want. But reiterating, I'm not giving them back. And so Chair Gentry was saying that land acknowledgements were kind of just a reminder, or could serve as a reminder of what the tribes had at one time, and then what they lost, what was taken from them, and then kind of that reality that continues today. So point is, I heard from one tribal representative that they were a good beginning. I heard from another tribal representative that they were actually really harmful. Based upon that conversation with Chair Gentry, I went back and started from scratch and rewrote the guidance, basically saying, don't do them. Don't provide land acknowledgements. There are too many opportunities to get it wrong, for intentions to be misconstrued, for people to be offended, even though that's not in the intent. And I presented this new guidance to the commission. Chair Gentry was a member of the commission at the time. And I presented it just a couple of days after this meeting with Chair Gentry. And the response that I got from Chair Gentry, he was the first one who spoke up when presenting this guidance document to the entirety of the commission. And he said, I think we're missing an opportunity here. And I kind of just chuckled and said, it's because of our conversation that I've written the guidance document in the way that it is. And what that really reinforced to me is that there is no tribal perspective. Whatever the question is, whatever the issue is, and in our purposes here, when we're talking about consultation and the expectations, it depends on the tribe that you're talking to. It even depends on the individual within the tribe that you're talking to. Like any other person or group of persons, those perspectives are going to change. And so really what it comes down to is, and we'll get into this also a little bit later on, it comes down to building that foundation and building those relationships so that you can develop that better understanding, more comprehensive understanding of what the expectations are. Taking a step back and talking about that different perspective and the different paradigms that exist. So I have a couple of examples, and one of the things I want to emphasize in these next few slides is the difference between some of the East Side tribes and West Side tribes, but also the differences between what you will hear referred to as treaty tribes and non-treaty tribes, which I think is a bit of a misnomer, but it is a way of discussing differences between the tribes that I've heard used by non-tribal members and by tribal members. So here's an example of two maps of the lands of the Confederated Tribes of the Umatilla Indian Reservation. And I put these two maps up there because it really shows the different perspectives. The left-hand map is the one that we're all familiar with, or at least to some extent. If we still used paper maps and we didn't use Google Maps or whatever as we're traveling around the state, but we pulled out our old atlas or our old map of the state, what we might see, the left-hand map shows in dark green is the Umatilla Indian Reservation. That's the dark green. The light green is labeled as Aboriginal title lands. And if you were to look at the treaty with the Umatilla, that treaty clearly defines what the United States saw as the boundary of the Umatilla lands. Now, that description was not based upon what the Umatilla said their lands were. That was what the United States said Umatilla lands were. That's their Aboriginal title lands. But those are the lands that the Umatilla ceded under the treaty, and then they retained the dark green, which is their reservation lands. The right-hand map is also, and both of these maps are off the Umatilla tribe's website, but the right-hand map shows the traditional use area of the confederated tribes of the Umatilla, the Cayuse, the Umatilla, and the Walla Walla. And you can see that that right-hand map shows a much, much bigger area than the left-hand map. The reason I point this out is because it's a matter of perspective. There is a statement that I heard recently from Chair Mead with Coquel, and she was saying when it comes to consultation, if the state is contemplating taking an action on tribal lands, the state should be engaging in consultation with that tribe. Well, tribal lands, I guess, depends on your perspective, because when she is saying if the state is contemplating taking action on tribal lands, I would be willing to bet that her reference is to the lands as recognized by the tribes as their traditional use areas, not modern day reservations, not even the lands that were ceded as identified by the United States in the treaties, but tribal lands as the tribes understand them. And so that's a perfect example of kind of that different perspective and that different paradigm. I think it's a perfect example of, how an apparently facially or superficially benign statement, if a state is taking action on tribal lands, can have multiple meanings because it depends on how you define tribal lands and whose perspective you're viewing that through. Similar map for Confederated Tribes of the Warm Springs. The left-hand map is the Warm Springs Reservation in pink. You can see that with the dotted line in pink around the outside, as it says, that's the Warm Springs ceded lands, as per the Treaty of 1855. But then if you look at the traditional use areas on the right-hand side, the traditional use areas were much larger than are depicted on either left-hand map with either perspective, whether we're talking about reservation lands or ceded lands. So it's just good to kind of have that understanding that maybe when we're talking about tribes and tribal interests and tribal lands, there's something far more broad than we have traditionally thought of through our educational systems, what we've been taught since we started learning about these issues in elementary school and beyond. Now, similarly, with the West Side tribes, we got the Confederated Tribes of the Silex. And while the East Side tribes, keeping in mind, even those confederations themselves were something that were imposed upon the tribes. I'll use the Warm Springs as an example. The initial treaty with the Warm Springs confederated the Warm Springs and the Wascos. And it was only later that the Paiutes were added in to that, so that now the modern day iteration of the Confederated Tribes of the Warm Springs is the Warm Springs, the Wascos, and the Paiutes. With the Confederated Tribes of the Silex, and as you can see in the header, in case any of you are interested, this is a link to their website, and so this information is coming from the Silex website. But rather than talking about their different bands that were consolidated or confederated, they are looking at language groups and larger tribal affiliations, but that brings the tribes that they refer to a much larger group, the Clatsop, Chinook, Klickitat, Molalla, Kalapuya, Tillamook, et cetera, et cetera. And similarly, you can see based upon that description, or depiction, you can see the different versions of maps here from the Siletz as far as their traditional use areas. And we talk about treaty tribes and non-treaty tribes, and you'll start to see this a little bit with I'm going to talk about Coquel briefly next. But there isn't necessarily just one treaty. My understanding of this is, when I hear tribes talk about treaty tribes and non-treaty tribes, I view that as a bit of a misnomer because all of the tribes in the state of Oregon, all the federally recognized tribes in Oregon, have a treaty history. That treaty history differs, right? But they all have treaties somewhere in their history, treaties with the United States. And so, for example, the Siletz have a treaty that was in 1853 that was ratified. A few days later, there was another treaty, which also ultimately was ratified. Over the next 2 years, there were multiple treaties, a total of 7 treaties. All of those were ratified. And then another treaty in 1855, which was not ratified. And then the Coastal Reservation was established by executive order in 1855. Just a brief note there, as you all probably know, the ratification, the treaties were signed by the tribes. They were signed by delegates from the United States, but for that treaty to take effect, it had to be ratified by Congress. And so the point to all of this is there were multiple treaties with the Confederated Tribes of the Siletz Indians, most of which were ratified, but one which was not. And then perhaps one of the more extreme examples is the Coquel Indian tribe. They had treaties that were signed in 1851 and again in 1855. As usual for treaties, they surrendered, ceded large portion of their lands in return for the promises of payments, provisions, etc., and a reservation. They ceded more than 1 million acres through those treaties, but Congress never ratified those treaties. And so the Coquel also have that treaty history, and I would argue are a treaty tribe, but their treaties were never ratified. And so that's the distinction that we'll hear today, sometimes talking to some of the tribes, is 2 of the tribes that are referred to as treaty tribes, the Warm Springs and the Umatillas. Those tribes, their treaties were signed, they were ratified, and they remained intact until today. So with that understanding of those different perspectives, and I'm going to dive a little bit further into some of that history with treaties and what I mean by intact until today. But with that basic understanding of those treaties, the treaties and case law and statutes and whatnot establish that tribes are unique legal entities in the United States, distinct political communities, powers of self-government. That sovereignty predates the United States. And even the Constitution considers tribes as separate governments. And, the third bullet point, tribal sovereignty predates the United States, is an important point. Again, it's a paradigm shift. Sovereignty is something that the tribes had before they signed the treaties. The tribes were all inherently sovereign in their own existence prior to that westward expansion. Reservations did not give sovereignty to the tribes. The tribes already had that sovereignty. Just like even the treaties and reservations, the term reservation, those lands were reserved. Those lands were not given to the tribes through the treaty. They were reserved by the tribes through the treaty. This just kind of reinforces this notion that treaty statutes and executive agreements have established this trust relationship. By those treaties, many tribes ceded almost all of their lands, and they retained reservations. Most of the treaties in the Northwest were in the 1850s to 1860s, and if you look at many of those treaties, there's a substantial similarity in the language because they were Indian agents who wrote them. Palmer and Stevens were the authors of many of these treaties, and as you would expect, they had a template that they were going off of when they wrote the treaties. So you'll find common phrases and common language, for example, around hunting and fishing rights and things of that nature. So there are significant similarities among those treaties. And just as a reminder, Article 6 of the United States Constitution states that all treaties made shall be the supreme law of the land. I think that's an important point to remember too in this discussion, is that treaties were entered between the United States and the tribes. And it's a fundamental notion that treaties are entered into among, I'll say, equals, not necessarily equal in power, but equal in authority. As an example, if the state of Oregon had a dispute with the United States would never enter into a treaty with the state of Oregon. Or if it was a state in Mexico that had a dispute or a disagreement with the United States wouldn't enter into a treaty with that state within Mexico. The United States would enter into a treaty with Mexico or with Canada or with another sovereign nation. And so when the United States entered into treaties with the tribes, they were indicating, the United States was indicating that they were entering into a treaty with a political equal, with a separate sovereign. And that's an important point for us to remember, if for no other reason than as we're contemplating how to engage with tribes and when to engage with tribes, and what that engagement should look like or sound like. When you write a letter to a tribal leader or to tribal council, that's the level that you're writing that letter to. I think it's an interesting notion when we think about government to government communications. A lot of times at the agencies, we think about that as comes from leader and goes to leader. But clearly a director of an agency is not on par with the chair of a tribe. It is leader to leader, but it's not on equal footing, right? So I think it's just important to remember that it's a good framework for when we think about how to engage with tribes and what that engagement should look like. So we've talked, I briefly mentioned treaties that stayed intact up to date. And that's because in 1954, there was the Western Oregon Indian Termination Act, which effectively ended the federal government's trust relationship, eliminated those treaties with most of the tribes, the federally recognized tribes of Oregon. It's basically an attempt at assimilation. There are multiple levels to the Indian Termination Act in Oregon, multiple ways to view it, many rationales that are stated. On one hand, the United States, in some ways, was saying this separate sovereignty, the dependent sovereign within the United States wasn't working, and all people just needed to be citizens of the United States, and there was an assimilation into mainstream society. Not only did that assimilation take away the lands that had been retained or reserved, but it also took away all of the support programs and everything else that had been promised. But of course, no funds were provided in order to replace that. So that was the assimilation. Now, perhaps not coincidentally, I think everybody understands that the Western Oregon tribes that were terminated also had a lot of resources that were recognized in the 1950s as valuable resources. As an example, the Klamath tribes will be quick to tell you that they had one of the largest stands of ponderosa pine in North America at the time that their treaty was terminated. And because of termination, those lands were taken away from the Klamath, and then those lands were distributed either to industry, timber industry, or to other settlers, farmers, ranchers, people that had come out west. And so there is a strong argument to be made, and I believe it's been made and fairly well documented, that a lot of the assimilation also and termination might have had something to do with access to those resources. But then in the 1970s and 1980s, the United States reversed course again, and through executive order restored the rights of those Western Oregon tribes. And so I keep saying Western Oregon tribes. I've mentioned the Burns, Paiute, and the Umatilla. The Western Oregon Termination Act expressly did not apply to the Warm Springs and the Umatilla. And so those treaties from the 1850s time period remained in place. through termination because they weren't impacted by the Western Oregon Termination Act. In the 1870s and 1980s, as you can see, there was a strong effort towards the restoration of those rights, and it was obtained, but that restoration only reestablished the government-to-government relationship between the tribes and the federal government. Notably, at that point, all of those lands that had been taken under termination had been redistributed to others and could not be given back. So just kind of adding insult to injury and continuing our treatment of the tribes from the time of westward expansion in the treaties. We entered into a bargain, signed treaties, made certain promises, failed to come through with those promises, under termination, reneged on those promises, took the lands that we had recognized as theirs and were reserved by them. And then even upon restoration, we couldn't even make those reparations because those lands had already been redistributed. So I kind of go through that history just to make sure that we're all starting from the same place when we talk about that tribal perspective and tribal paradigm and the other perspective that exists out there, which is so different from the perspective that most of us were raised with and taught throughout our education and the understanding that we have, most of us or many of us have today. It's a very different story and a very different perspective than we're accustomed to. So that brings us up to today and some of the foundations that we have when it comes to consultation and working with the tribes. So you saw the time frame for restoration, and right around that same time in the 1970s, there was a recognition that treaties, as we've been talking about, create these obligations and this formal government-to-government relationship between the United States and the tribes. But no such pathway or legal relationship existed at the state level. So in the 1970s, the legislature created the Legislative Commission on Indian Services. And these are just the words directly from 172-100 that first states the purpose of the commission and second acknowledges that the creation of the commission can't abrogate or supersede any negotiations or relations that already exist, specifically through treaty. This was an important step within the state of Oregon and remains a unique step within the state of Oregon because we are still the only state in the nation that has a commission on Indian services, a legislative commission on Indian services. And that first word is the important distinction. In every other state, my position as the director would be within the executive branch. I would be in the governor's office, special counsel to the governor. In the 1970s, the legislature made the decision that they didn't want this position, this liaison between the state and the tribes, to be in the executive office. They wanted it to be in the legislative branch. And that's had two consequences. One, the commission is completely nonpartisan, apolitical. And two, we are not, and I don't mean this in a negative way, but we are not beholden to a governor's agenda. We are the Commission on Indian Services, which, as you will see on this next slide, is one member from each of the 9 federally recognized tribes of Oregon, and then 2 members from the House, 2 from the Senate, Republican and Democrat each, just to reinforce that nonpartisan nature of the commission. The other consequence that exists, in addition to being outside of the executive branch, as part of being outside of the executive branch, as you all know well, whenever there's a change in administration, frequently those cabinet level positions change as well. And so by being in the legislative branch, we don't have a change in leadership of the commission just because we have a change in governor. A perfect example of that is not my immediate predecessor, but kind of the longest term predecessor at the commission, Karen Quigley. She was the director of the Commission on Indian Services for nearly 26 years. Had this position been within the executive branch, within the governor's office, I think it highly, highly unlikely that there would have been one individual who would have been able to develop those relationships with the tribes, that understanding of the tribal perspective, and been able to kind of navigate that role of diplomacy between the state and the tribes. We wouldn't have had one person fill that role for 26 years. That's just not the way those positions are filled within the executive branch. So there are a couple of benefits. One can argue how intentional those benefits were, but I think it was pretty clear that the legislature made a very deliberate decision to place this position, this liaison role, within the legislative branch. As such, we hold quarterly meetings to basically bring the state and the tribes together. The commission will invite agency representatives to come into the commission meetings to make presentations, to engage in dialogue with those tribal representatives. And it is a two-way exchange. It does not replace consultation. It does not equate to consultation, but it is kind of an opportunity for the state agencies and the tribes to first have some conversations or get updates on issues that are important to the tribes and the state and that nexus between the two. And then in 2001, that government to government relationship was formalized. And this is where we're going to start to get into the meat of what will probably perhaps be most impactful and informative to you all as to what the understandings are when it comes to consultation. So in 2001, 182, 164 was passed. You'll hear that referred to as Senate Bill 770. I always cringe whenever people refer to initiatives by the Senate bill because those Senate bill numbers are, it's which session, Senate Bill 770 from which session. But when it comes to state tribal relations, if you hear reference to Senate Bill 770, what you're really hearing is reference to ORS 182, specifically 182, 164, and the related statutory sections. But that's what required state agencies to develop and implement a policy to promote communication between agencies and tribes, identify programs that affect tribes, and coordinate with tribes in the implementation of agency programs. I think this is just the direct phrasing from that specific statute. And so when it comes to the tribes, the first bullet point was talking about a tribal relations policy, which hopefully everybody in this meeting, your agencies have that tribal relations policy because it's statutorily required that every state agency have a tribal relations policy. That tribal relations policy is going to identify who your tribal liaison is within the agency. It will talk about how your agency is going to engage with tribes and promote communication between your agency and the tribes. And it will also kind of document how that has happened on a year-to-year basis, because one of the other requirements is that annual report be submitted to the Commission on Indian Services and the governor's office to outline what your agency has done in the context of government-to-government relationships with tribes. Let me pause for a second, too, to talk about your tribal liaisons. Right now, I can't see who all's in the virtual space here. Some of you may be your agency's tribal liaison, some of you may not. But a lot of what we're talking about here and a lot of what we will continue to talk about is information that your tribal liaisons have. And I would say that your first line, if there's a question or a concern or just even dialogue internally that's necessary to talk about whether something rises to the level of consultation, is to bring that to your agency's tribal liaison. A lot of what we're talking about here, and there's going to be a lot of information that's presented during this time period, and I don't think anyone expects everybody in this virtual space to remember all of this and to have a complete understanding of it. But by having a tribal liaison, you have somebody who is appointed within your agency that has a greater responsibility to be familiar with all of these issues and is that go-to person that you can seek out when you have questions. Of course, you can come to the commission, come to myself and the staff at the commission anytime you want, but your first line is to go to your tribal liaison within your agency. I want to dive a little bit more deeply into some of these requirements. So Section 3 of 182-164 says a state agency shall make a reasonable effort to cooperate with tribes in the development and implementation of programs of the state agency. You will note, if you dig into these statutes, that the word consultation does not exist. It's not stated anywhere when it comes to government relations, which is kind of surprising given the level of importance and the gravity of consultation and the need and requirement for consultation. But our statutes never talk about consultation. The closest we get is this section that says the chief shall make a reasonable effort to cooperate with tribes. A lawyer, such as myself, could make an argument that consultation is perhaps not required because our statutes only say cooperate. But I think that would be honestly a foolish argument to make. It's a legal argument, but it's not a sound legal argument because the practice has always been that consultation is required at the state level. That has been the practice for decades. That has been the expectation for decades. Just know that this is the genesis of that, or the basis for that requirement for consultation. And I also want to take a step back here. One of the things, let's see. I want to dive specifically into state agency, and I think this really impacts anybody here other than to understand the breadth and requirement. Why consultation? State agencies, as we read in that last section, are who's required to make a reasonable effort to cooperate with tribes. And then in 182-162, the definitions, state agency has the meaning given that term in ORS 358. So why not? Let's go to an entirely different statutory scheme to talk about what state agency means. But as you can see, state agency includes all officers, employees, agencies, boards, committees, commissions of the legislative, executive, administrative, and judicial branches. So state agency isn't just what we think of as executive branch state agencies. It's all officers, employees, agencies, boards, commissions, etc., of the legislative, executive, administrative, and judicial branches. Basically everybody within the state. And there has been a realization over the last few years of the breadth of this requirement. Two examples come to mind. Many agencies are governed by boards. The Board of Forestry, for example, the Fish and Wildlife Commission for ODF&W. It's not uncommon for those leadership entities to not realize that this requirement for consultation extends to them as well. My experience has been that agency directors know full well that the agency is required to engage in consultation, but those governing bodies don't realize that it applies to them as well. A perfect example is the Board of Forestry, where the tribes were invited at the last retreat that the Board of Forestry had down in Medford to meet with the Board of Forestry. And it was the first time that the tribal representatives and the commission had been invited to that forum to meet directly with the members of the Board of Forestry. And it was in that exchange that the realization became clear to the members of the Board of Forestry that this requirement for consultation applied to them as well, by definition of state agency. Similarly, I've had conversations with legislators and legislative staff who were unaware of the fact that this requirement for consultation applied to them as well, because the notion was always, it says state agency, without understanding or realizing that the state agency was so broadly defined. So I think that just lends even more credence to how broad, reinforces how broad this expectation is. So why consultation? Because it's required by law. And there's federal guidance as well. Let me skip ahead a couple here, and I'll come back to those. I would argue that consultation is also a good thing to do because it's the right thing to do, not just because it's required by law. So in my mind, it's one of those, it's a two-pronged approach. It's required by law, and if that's not good enough for you, it's also the right thing to do. Consultation will allow for better communication, better collaboration, informed decision-making, And perhaps that last bullet point for many agencies, especially for management level staff at agencies, it helps avoid future conflict or litigation. It's not a guarantee. Engaging in consultation doesn't guarantee that you're going to avoid future conflict or litigation, but at least it makes it far more likely that you'll be able to avoid conflict or litigation because you've engaged in that consultation with the tribes. You've had that ongoing discussion, that relationship with the tribes. You've arrived at a result that is at least more palatable and at least more beneficial to all involved. And so therefore it's less likely to lead to conflict or litigation. So it's the right thing to do. Now, that brings the question, well, what is consultation and what should it look like? And through all of this, and what will probably be in some ways the least helpful to you today, is we have no definition of consultation. There is nothing written that provides guidance for us at the state as to what consultation is supposed to look like, when it's required, what should happen, anything of that nature. I will say that in the last long session, there was a bill that was passed. Representative Sanchez was the sponsor of the bill. And Representative Sanchez created a task force on consultation. And the effort is to bring together tribal representatives and state agency representatives to have a focused conversation on what is consultation. I can tell you the genesis of that was through some conversations at the commission. There was a federal effort introduced by Representative Grijalva a number of years ago that was called the Respect Act. And what the Respect Act did is at the federal level, it would have defined consultation. What's required? When is it required? What does that conversation need to look like? It would have defined consultation. And at the same time, it would have provided for some sort of judicial or quasi-judicial review. If a tribe felt that consultation hadn't happened and that consultation as defined in the Respect Act had not occurred, there would be an opportunity for that tribe to bring a legal action for review to determine whether consultation had been satisfied or not. And those are kind of the two poles that exist at the state level too. And so to sum that up, what happened to lead to this task force is that there had been discussions at the commission about the Respect Act, and instead of just introducing a bill that would have mirrored the Respect Act but made it a state level endeavor, Representative Sanchez wanted to convene this task force to the tribes to see if there could be agreement on what consultation should look like. And I was getting to the two sides to this issue. I frequently hear from tribes frustration because consultation, they feel, did not happen and did not happen effectively. And similarly, I will hear from state agencies frustration because they're not sure what they're supposed to do or what this consultation thing is supposed to look like. And so this definition would provide greater clarity. It would let the state agencies know what the tribes are expecting and what the agencies are legally required to do to formally engage in consultation. Similarly, with that clearer definition, there's the potential for some sort of review to ensure that that is being complied with. But you're never going to get, in my opinion, any sort of judicial review unless you have greater clarity as to what is expected. We don't have that currently. And Representative Grijalva's efforts failed at the federal level too. That bill never made it out for hearings and did not pass as law. But it is an example of the efforts that are underway at both the state and federal level to bring that greater clarity. That being said, even though we don't have anything that clear as to what is required or what is expected by the tribes, we do have some federal guidance that exists. And on the LCIS website, there's some tabs on there. One of those tabs is education, and it has information in there for anyone who wants to access it. And what we've put on there is some of the federal guidance that exists. And so I put this on there, certainly not binding. but it's informative. There's federal guidance that dates back from the Clinton administration in 2000 that starts off talking about consultation and coordination with Indian tribal governments. There is a hot link on there that can be utilized to go to the full document. This is just the beginnings of it and provides with some definitions. But the short of it is anytime in the way we understand it at the state, anytime an agency is contemplating an action that has the ability to impact tribes or tribal interests, the state should be engaging in consultation. And so this gives a little bit more narrow definition, policies that have tribal implications, but even though it's more narrow, it's not necessarily that much more useful than that vague definition that we have, because there's just so much room for debate as to when it is and isn't required. So for example, other policy statements or actions that have substantial direct effects on one or more Indian tribes. Well, how do you define substantial, right? That's open for discussion. But this document at least provides some guidance. More recently, 2021, we have another memo from the White House, Memorandum for the Heads of Executive Departments and Agencies, Tribal Consultation and Strengthening Nation-to-Nation Relationships, further reinforcing and clarifying the expectations. And then last, in 2022, most recently, Memorandum on Uniform Standards for Tribal Consultation. Title is extremely hopeful that you're going to get some direct guidance. I can assure you reading the document is instructive, it is informative, but it still doesn't give you that black and white answer of what do I need to do and when do I need to do it. But it does just reinforce that notion that the federal government is very aware of the obligation that it has to the tribes and that it is obliged to engage in consultation. And the reason that I think that's important is, again, from the other perspective, tribes receive requests from governmental entities to engage in consultation on a daily basis. They receive those requests from federal agencies and they receive those requests from state agencies. The federal agencies have much clearer guidelines of what is required, but when you look into these three documents, you'll notice some similarities to our statutes that talk about agencies being required to develop a tribal relations policy, being required to submit reports to the executive, talking about how those agencies plan to engage with tribes, identifying individuals within the agency that are responsible for kind of overseeing those tribal relations, so the tribal liaisons. There are substantial similarities, but when the federal government is approaching tribes with requests for consultation, and then the state is approaching tribes with requests for consultation, although we don't have memoranda like these three documents, or executive orders like these three documents at the state level, we see these documents at the federal level that lay out a bit of a framework. And the tribes have a very reasonable expectation that the federal agencies and the state agencies are going to approach consultation in, if not the same, at least a very similar way. So what I would encourage all of you to do is, if you are in a position where you're looking at consultation and the needs for consultation and want to just have a better understanding of what the tribe's expectations are when it comes to consultation, I would take a look at these three documents, and it will give you that clearer picture. Again, it's the federal requirement, not state, but it is instructive as to what the tribes are going to be expecting. So I think of this in terms of diplomacy. Because we don't have that direct guidance, and because we don't have any written documents that tell us exactly what we need to be doing, it comes down to relationships. It's all about building relationships. I alluded to this a little bit with our previous director here at the commission. It's aided by each agency having a tribal liaison and an individual within that role that can provide that perspective for the agency based upon the conversations that they're having with tribes, with tribal staff, and with those partnerships that they develop. It's critical to develop and maintain relationships before there's a need or crisis, like any other diplomacy. And with any other relationship, that firm foundation is essential. That's because when missteps occur, there's room for forgiveness. I've seen instances where agencies have found themselves running afoul of tribes on the consultation question. A couple of years ago, there was an issue with a board that had an issue pending before it, or an application pending before it, that the board needed to make a determination on. And this would have had a significant impact on tribes and tribal interests. And the board was leaning towards approving this application uh, over the objection to tribes. And even by that own board's or commission's statements, consultation had never occurred. In fact, that commission didn't have a tribal relations policy, didn't have a tribal liaison identified. And so the first time that there is any interaction between that commission and the tribes of Oregon is when there's a crisis and a conflict. And because there had been no foundation laid, including no tribal relations policy, no tribal liaison, there was no foundation to build from or to give that room for forgiveness. The first interaction is that negative, very negative interaction. Conversely, I've seen other agencies, large agencies, Oregon Department of Fish and Wildlife being one, commonly finding themselves in a position where there may be a conflict with a tribe or the tribes in general. But the Oregon Department of Fish and Wildlife has a long history of working with the tribes and having a tribal liaison in place. And they've developed that foundation that at least allows room for forgiveness when there is a conflict that has come up, because there is already a relationship in place. So that's why I say think of it in terms of diplomacy. That's why for all of you out there with your respective agencies, make sure you look at those tribal relations policies, make sure you know who your tribal liaison is, and make sure that you, at any opportunity that you have the opportunity to build a relationship, take advantage of that opportunity to build a relationship with the tribes. I know it's not realistic for many of you within your scope of work, but if you have an opportunity, as something comes up, as your agency is working on a project, as consultation is going to be an issue and you're involved in that project where consultation is going to be necessary, if you can, take the time to go to that tribe or those tribes that are going to be directly impacted by your agency's actions or by your project, and go to tribal lands and meet with tribal members, tribal council, tribal chairs, whoever the audience is that is given to you. Meet with the tribe on tribal lands, and it will give you a whole different perspective on what the issues and concerns are, and it will help build that relationship, the familiarity among not just your parties, the entities, but among individuals. I know that's not practical for all of you, but if you have that opportunity, I would encourage you to take it. Um, the tribes are so accustomed to being summoned to Salem for conversations that when Salem takes the opportunity to go to the tribes, that is recognized and appreciated. And it goes, I can't emphasize enough how far that goes in building that good relationship. So think of it in terms of diplomacy. Build those relationships anytime you get the opportunity to do so. Kind of along those lines, you need to build trust, and you need to have mutual respect. And you also need to recognize the shared responsibility that exists within consultation. You need to have that knowledge of the 9 federally recognized tribes within Oregon. And like I said, the established relationship and an awareness of similarities and differences between each of the tribes through any opportunity that you have, whether it's through visits, through talks, through trainings like this, independent study, and looking into some of these issues, going to those websites. Each of the tribes on the Commission on Indian Services, one of the tabs is the 9 tribes of Oregon. And if you hit on that tab, the drop down is for each one of those tribes individually. And there's not only information that they have uploaded about their tribe on the website, but there's also a link directly to their website. And they are a wealth of information. They have history there. They have current affairs, current issues and concerns. Each tribe, they're their own websites, so they vary significantly from one tribe to the next, but there's all kinds of information there. And so I would encourage you to take the time to get to know those tribes and do that in particular before you reach out and have those conversations on any particular issue with the tribe. So you yourself have a foundation to work from. And then lastly, recognizing that each one of the 9 tribes is a distinct sovereign entity. And like we started off by saying, there is no tribal perspective, that each tribe is different. Stories, I got a million of them, but one of those examples is every year the governor's office hosts an annual summit with the tribes. And historically, like under Governor Brown, Dustin Bueller was in her office. And in advance of the summit, Dustin and I would get on the phone and we would call each tribal chair to have a conversation with them about what topics they wanted to hear addressed during that annual summit. Our first call was to, I believe it was Coquel. And to boil it down, what they wanted to hear about was water and salmon. And our next call was to the Grand Ronde, and what they wanted to hear about was water and salmon. Same thing when we called the Silettes. And Dustin and I were thinking, well, we're getting a pretty clear direction here as to what we need to be talking about at the summit. The next call was to Cow Creek, and they wanted to hear about water and salmon, but their first priority was they wanted to hear about economic development, employee recruitment, and housing. And Dustin and I kind of looked at each other and thought, that was not the direction we thought that was going to go, but it was a perfect example of how every tribe is different. And to assume that because you've talked to one tribe, or in this instance, 3 tribes, you know what the perspective is of all 9 would be erroneous. So you need to keep in mind that each one is separate and each one has a different perspective. And you will see that play out. And one of the mistakes that you can make is to assume that they are all going to be the same based upon what you've learned from 1, or in this instance, 3. So as I've said, you need to acknowledge that two-way nature of consultation. I would suggest that you think about the need to coordinate with other state agencies or departments. If there are other agencies, other state entities that are directly implicated in your projects or your programs, you might as well bring them to the table as well when it comes to the consultation discussion with particular tribal governments. And certainly don't forget or overlook the need to consult with tribal governments. And I think we'll get to it. Let me see if it's a common pitfall. So we've already talked about the one size does not fit all. Just because you've had an experience with a tribe in the past does not necessarily guarantee that that's the way that things are going to go in this discussion or in future discussions. Like any other sovereign nation, like any other entity, even within agencies, as you get changes in leadership, you get changes in priorities, you get changes in perspective, and you get changes in expectations. So just like from the executive side, if you had a change in administration and you had a change in leadership within your agency, you might have a good idea of the way you expect things to go once that new leadership comes in. And that's a good idea of how it's going to go, but be ready to pivot and recognize that things might have changed since the last time you had a conversation with that tribe. Keeping up with changes in tribal government. Not knowing the priorities of those governments, using the same approach for all of them. Those are all things that we can help with at the commission, where you can reach out to us. So first of all, frequently we get phone calls or emails from agency representatives, from agency staff on a particular issue saying, hey, here's what we're looking at. I'm not really sure that this rises to the level of consultation or not. What do you think? Should we reach out or should we not? And so at the commission, we're able to help out with some of those conversations. Again, we can't necessarily give you the definitive answer, but I can give you a pretty good idea based upon the conversations that I have with tribal chairs and tribal staff on a regular basis. That kind of also brings up the notion, if you look at that statutory requirement, if you look at the notion, the idea that anytime an agency is contemplating an action that has the ability to impact tribes or tribal interests, they should engage in consultation. That's frighteningly and remarkably broad. Tell me about an action that an agency is contemplating that doesn't have the ability to impact tribes or tribal interests. Just about everything that that agencies do is going to have the potential to impact tribes or tribal interests to varying degrees, but to some degree. And the reality is you can't, the agency can't, nor do the tribes want you to seek out consultation on every issue that you're looking at. And I think that's where that language came in from the federal guidance with the significant impact language, where you try to take a look at what you are engaging in, what your agency is engaging in, and think about the significance of it and how likely it is to impact tribes and tribal interests and to what degree. And it's those higher level issues that you're going to want to seek out consultation with the tribes. That being said, you'll sometimes hear the differences that people will talk about big C consultation and small C consultation. I don't like to use that distinction because even as we're sitting here having a conversation, even in the written language, you don't capitalize consultation when you're talking about government to government and make it a small c when you're talking about something less than. And in conversation, you can't distinguish between a capital C and a small c. So I like to refer to consultation and coordination. Consultation is that government to government communication, the formal government to government communication. And coordination is what happens every single day at the staff level. You have either you yourselves or people within your agencies engage with tribal staff on a routine basis. And context that I think of, well, let me first say that coordination, and one of the earlier slides talking about Senate Bill 770, at the bottom it talked about the cluster groups, and many, if not all of you, know that there are kind of subject matter specific work groups. There's the cultural resources cluster, the natural resources work group, the public safety cluster, the education cluster. And those subject matter specific work groups are comprised of tribal staff that work within that discipline, and then agency staff that also work within that discipline. And so, for example, cultural resources cluster is generally all of the tribal archaeologists, and then state agencies that have the potential to be interacting on that cultural resources level. So, for example, ODOT, ODF&W, Oregon Department of Forestry, Department of State Lands, Oregon Water Resources, DEQ, agencies that might impact, their actions might impact cultural resources. Many of those agencies are also in the natural resources work group. But it's tribal staff and agency staff, not leadership, but staff that get together for those work group or cluster meetings to talk through some of those issues. And I would refer to that as coordination. It's not consultation, but it's coordination. It's what happens every day when staff work on issues of common interest and concern. Consultation can be a fluid thing. Sometimes there will be a request for consultation from an agency to tribal leadership, and tribal leadership won't feel that that issue rises to the level of or necessitates consultation, but they want there to be coordination between their tribe and the agency, so that tribal leadership will delegate that consultation request down to agency staff to handle it through coordination. Conversely, I've seen issues arise within those work groups or those cluster groups within that coordination setting that start off as simple coordination, but as the project increases in scope or magnitude, or has different unforeseen or unanticipated impacts and necessitates greater discussion, it can get elevated from coordination to consultation. So it's important to think of both of those avenues and utilize both, but also be flexible enough to allow your issues to bounce back and forth between consultation and coordination. But really, when it comes to the consultation component, giving that outreach to the tribes on that particular issue and giving them the opportunity to weigh in as to whether they want that government to government interaction or not, that outreach in itself is critical. You are giving the tribes the opportunity to make their own decision on that. Last thing I'll say on that is, do not be frustrated if you don't get a response to your consultation requests. I've seen agencies, I've heard agencies make the statement when they don't get responses to those consultation requests, that it leads to this sentiment that the tribes just don't care. And that couldn't be further from the truth. That lack of response could be because the request wasn't seen among the inundation of requests. And remember, I was saying, if you think about the number of tribes that we have in the state, think about the size of those tribes and those tribal governments, the staffing that they have. Then think about the number of state agencies that we have. And if state agencies are really following through with their obligation to engage in consultation when they should, think about the number of consultation requests that are happening from the state to each individual tribe. And then recognize that that same obligation exists, and probably to a greater extent, with all federal agencies as well. And that begins to give you an idea of how many consultation requests tribes receive on a regular basis. So when you don't get a response to your consultation request, that lack of a response does not mean that the tribes don't care. It could mean that they didn't see it. It could mean that they did see it, but it doesn't rise to the level of some of the other issues that are on their desk. One thing that I try to do to alleviate that I didn't see it result is that if I am writing correspondence for some reason to tribal leadership, and it's on a specific program area or subject, I will CC the people that work within that discipline, because those are the people who are going to be more likely to already know that this is an issue or a potential issue, and are going to be more personally invested in making sure that there is attention given to the issue. So once they see it, they can walk into the tribal chair's office or into tribal council and say, hey, just wanted to make sure you all saw this. So there are ways that you can go about, alleviating that lack of response. But if you don't get a response, A, don't take it personally, and B, don't assume that that means they don't care. And then the last box here, not allowing sufficient time. This is one that really takes a lot of effort to address. I put legislative timeline in there as a good example. Our legislative timeline is not conducive to consultation. The tribes will remind you often and repeatedly that consultation is not a check the box process. It's not a one and done. Consultation is a relationship. It requires ongoing discussion and dialogue, and it takes time. Our legislative timeline doesn't currently work on a timeline that is conducive to adequate consultation. At least it doesn't currently. It could, but that's not the way we employ it. And, a way that many of you may be familiar with, if an agency is contemplating a bill, if there's a legislative concept, frequently that legislative concept is brought forward to a legislative sponsor. And at that point, it is a legislative concept that may become a bill that will then be up for hearings, et cetera, et cetera. But that timeline is so compressed that unless there is outreach at the inception of that idea to the tribes to engage in consultation, there isn't going to be enough time in the process. If we are not engaging tribes until the legislative session has started, and we expect to get a response from the tribes between the start of the legislative session and the time when that bill is actually voted on, that's not enough time to engage in consultation. Perfect example is this last session. There was a potential for a bill. Actually, I think it made it beyond legislative concept. It was a bill, and it would have had specific implications regarding gaming in the state, which of course the tribes are all going to be interested on anything that impacts gaming within the state. And the legislative proponent, we had a Teams meeting and discussed, how best to reach out to the tribes and engage in consultation with the tribes on this bill. And I said, session has started. You don't have time to engage in consultation with all 9 on an issue like gaming between now and the closing of the session. The only way that you have time is if you're talking about engaging with the tribes on this bill in anticipation of the 2025 session. Then you might have time. And so for all of you, I would say, to whatever extent you get involved in that legislative component of your agency's work, when you start thinking about a legislative concept, if you think that it is going to implicate tribes and potentially rise to the level of consultation, I would have that consultation. I would start that conversation with them at the outset. At the same time that you are kind of letting that concept ferment internally, maybe even before you bring it to a legislative sponsor. But get the tribes involved as early as you possibly can. I know that in itself is a paradigm shift, and it's just not the way we've been accustomed to doing business. But once you start, as you know, the larger a project is, any project, the more people that are involved in that project, the larger a committee is, the more people that are involved, the more time it takes to get a result from that effort. And so now, when you are including tribes, when you're including sovereign nations, sovereign entities, you inherently are going to compound the amount of time that is necessary. So just keep that in mind. That even boils down to the level of project management. If that project is going to require consultation and engagement with tribes, just know that it's not going to be a one and done meeting. You're going to need to build enough time in. And so that's probably going to be time up front. Because whatever your project is, let's say it's boots on the ground type of project, if you're not engaging with tribes until the time where you've design the project, put it out for bid, brought in contractors, and boots are ready to get on the ground. If that's when you're engaging in consultation, you're way, way behind the ball. That you should have been engaging in consultation much earlier. So your resources that are available. I've already mentioned a couple of times that LCIS has a website where a lot of this information exists. We're always available at the staff level by email, phone, or in person. We do trainings such as this. Trainings, I will tell you, one thing that I hope will be very helpful to all of you is that we have been working primarily through the initiative of the Oregon Department of Education to put together a training series on sovereignty and consultation. And Oregon Department of Education has been coordinating an effort in conjunction with an entity called Region 16, where there are videographers, professionals in the trade going out and meeting with the tribes. And the tribes are able to, you know, identify specific individuals within the tribe to speak to sovereignty and consultation. What does sovereignty mean to the tribe, to that specific tribe, and what does consultation look like to that tribe? And sometimes giving examples of successful consultation, sometimes giving examples of failed consultation. But it is from that tribe's perspective. This video series will be a 10-part series, one for each of the 9 tribes, and those are, although the footage that's been obtained is a couple hours for each tribe, it's being boiled down for our purposes to 10-minute segments per tribe. And then the 10th segment will be from the state perspective, governor's office, Commission on Indian Services, state agencies. Give it all boiled down into 10 minutes as well, the state perspective on the need for consultation, what sovereignty means. That will be one collective, cohesive training segment that will be obviously a little bit over an hour and a half long. It should be done by midsummer and available for all. Oregon Department of Education will obviously have oversight of it, but it's, our understanding through conversations that material will be available for all state employees. And we've even talked about, having it available through DAS and available through Workday and on the training portal, things of that nature. But that will give you a very good overview of what sovereignty means to each of the 9 tribes of Oregon and what their expectations are when it comes to consultation. So that's an example of the training that we work on here at the Commission and that we help with on an as-needed basis. And then the last resource is, I put here your agency general counsel. I'll say internally, your tribal liaison. For each of you at your agencies, your tribal liaison is an essential contact when it comes to the issues that we've been talking about here. And you always need to keep in mind conferring with your agency general counsel, because they are going to be kind of your last line when it comes to legal implications regarding consultation, the needs for consultation, the requirements for consultation. And it's not my intention to be giving you any legal advice here that would be contrary to what your agency general counsel would say. I don't think I have. I don't think there's anything that they would disagree with. I think the only things that might arise would be when it comes to those timing issues and recognizing the pressures that all agencies face to get missions accomplished and tasks accomplished. That's an ongoing tension. So that's it for my presentation. It looks like we have a couple of minutes. I see a couple of comments in here from Mary at DEQ. I've been reminded that when we hold a public comment period, that tribes are not the public. They are separate government. And that is absolutely 100% true. I think that's, we were talking about ways that consultation can go wrong and that you can run afoul of the tribes. One of the first ways you can do so is to talk about the tribes in the same context or the same breath as the public, similarly to refer to them as stakeholders. So, public comment period, like for in rulemaking, things of that nature, consultation should have occurred prior to something going out for public comment. Tribes also will reinforce that they are not stakeholders because tribes are sovereign nations, and none of those groups that we think of as stakeholders, public interest groups, whoever they may be, none of them hold that special status as a sovereign nation, right? None of them have that legal status. So that is a big mistake that I frequently see made, and it's certainly not an intentional slight. It never has been. It's done, I think, often out of, again, for one of a better way to describe it, but out of ignorance, without thinking about the unintended implications of just lumping tribes together with those groups. Let's see, a couple other. Yep, I offer one-on-one outreach on my program to individual tribes versus webinars for local governments. And I'm feeling like I need to coordinate with interested tribes as soon as I take on a project that might have impacts. Absolutely. So that one-on-one outreach is critical, right? We've already talked about those relationships and the nature of those discussions and the respect for sovereignty that exists, and then the need to coordinate as soon as they take on a project that might have impacts. I think that's absolutely correct. Sometimes that coordination, sometimes that discussion starts with reaching out to LCIS and saying, hey, should we engage in consultation on this particular project? Sometimes with that specific discipline, wherever the project might be impactful, it's by taking that project to one of those work groups or cluster groups and bringing it up within that context to see what the tribal participants' responses are there. But there are a number of different ways that you can do that, but you can definitely start down that path early. The last thing I'll say, and this is more of just, again, paradigm setting. Think about the fact that there's somewhat of an intellectual exercise, but even when we talk about tribes as sovereign nations versus public or versus stakeholders, I've even seen some tension arise within the context of DEI. For example, with one larger state agency that actually has an equity commission within the agency, there was a discussion with that DEI context where there was a tribal member, a tribal formal commission member representative, who was insistent that any reference to tribes be removed from that DEI language in those internal documents. And that was because tribes as sovereign nations are sovereign nations, and no other group that is routinely represented by or considered within the DEI conversation has that sovereign nation status. Now, that's somewhat of an intellectual exercise because tribal nations arguably would not be part of the DEI conversation, but tribal members would be, right? So if you can keep that in mind as we're talking through all of this, I think it's just it again reinforces that notion of the significance of sovereignty and what that means to a tribal nation, and respecting that elevated status that tribes have. Mary, hand up.
Sorry. That's very interesting. I guess when I was thinking about DEI is that by the very nature, not so much their government, but what's happened to them. They are a group that doesn't have equal footing. And so if DEQ is sharing resources, they should be a group that is in that list of underserved groups. Is is that an okay way to think about that? Or should we just not even lump them into a DEI conversation because of their sovereignness of it? But again, a lot of them don't have a lot of resources, and if we're not thinking about them, we may not, give resources to them because we don't consider them as under-reserved,
Right.
underrepresented.
You raise an excellent point. And I think that to me, the nut of your point is that you are recognizing kind of the disadvantaged status, the inequality of treatment and opportunities and availability. And that's the important thing to think about, and think about how you're going to address that and approach that. I kind of only brought up that last example just so that you all can be mindful and not necessarily be surprised if for some reason you're having a conversation and it's within the context of DEI, as we have traditionally come to think of DEI. I say traditionally, even just within the last couple of years, right? But as the way we usually employ that term or terminology, and recognizing the sovereign nature of tribes as a government, right? So I just don't want you to be surprised if you're having that conversation and all of a sudden you get a little bit of pushback from a tribe, because there is that complexity of, well, tribal nations are sovereign, but tribal members would be entirely appropriately considered within the context of DEI, on their individual status, right? So the only reason I brought that up was twofold: to reinforce kind of the significance of that sovereign status, but also to give a little bit of fair warning that I've seen this be a point of friction at times, and at least you can understand where that point of friction is coming from. Everything that we've talked about today, I can't offer you the solution, right? We're not going to fix everything, but at least having a better understanding of maybe why these points of friction exists and why these points of tension exist will help us in those conversations as we move forward.
Thanks.
Sure. Anybody else? Coordinate with LCIS first, then TIPO SHIPO. Hell, I'm going to be a lawyer. It depends. In what context?
Well, I'm just working with Mary on some brownfield projects. And so I'm just really curious, I really want to bring them in because we do have limited time frames too, where we're trying to get responses. And so if we're only giving them 30 days, it's like, wow, but our projects are rolling and, we've got to work on the whole grant portion of it and everything. And so that's where it gets complicated because we just don't have the time oftentimes.
Well,
Right.
so Patrick, we would go to Roxy, who's our liaison. So
Yep.
she's the coordinator and she does the cultural clusters. And I actually have attended clusters and I was the project manager for Jordan Cove. So I had some experience with tribes and been chewed out and did the whole public thing and stakeholder. Yeah, it's fun, but you got to learn. So it is what it is. But so Tina, normally we can refer to Patrick, but usually Roxy does that. And then we would do the TIPO SHIPO thing, depending on what this is, if we're disturbing land or sediment in our case. So, and Patrick, I was asking a question, if there was a non-federal tribe, could we connect with them? And Roxy said no, because of what's recognized and not recognized. My idea was fine, but it can cause conflict between the recognized and non-recognized. So that was interesting too, that, it's, you just need to ask before you leap and
Right.
just think things through.
Yeah, no, that's an excellent point too. So there are 9 federally recognized tribes in Oregon. There are a lot of other tribal entities in Oregon that are not federally recognized tribes. And the key word there is federally recognized. And part of that is that the state of Oregon has nothing to do with which tribes are and are not federally recognized tribes. That's a BIA federal recognition thing. And there are tensions that exist. In my guidance, acknowledging I'm the director of the Commission on Indian Services, and the commission specifically is comprised of the 9 federally recognized tribes of Oregon, and that's where my primary legal obligations lie. I always I tell people to exercise caution on behalf of the state when reaching out beyond those 9, because there are certain tribes, for example, that are seeking greater level of recognition within the state, and sometimes recognition equal to that is granted to those federally recognized tribes of Oregon. And as soon as a state agency starts treating other tribes beyond those 9 equal to those 9, you're kind of creating precedent and you're opening the door. And my question has always been, who is going to be the arbiter when that next request comes in from another tribe? So, for example, even among federally recognized tribes, the Nez Perce are a perfect example, because the Nez Perce, absolutely no dispute by any of the 9 federally recognized tribes of Oregon that the Nez Perce have ancestral use areas, they have lands, they have ceded lands pursuant to treaty within the state of Oregon. They have a modern day presence within the state of Oregon. But by federal standards, they are technically a federally recognized tribe of Idaho, because that's where their tribal offices and headquarters are. None of the 9 federally recognized tribes of Oregon would dispute that the Nez Perce have legitimate claims and interests in Oregon. But if we now, even though the statutory mandate is to the 9 federally recognized tribes of Oregon, we now kind of by default treat a 10th tribe the same way as those 9. Another example is the Tolowa Dene in Northern California, who assert that they also have lands within the state of Oregon and rights within the state of Oregon. And some of the Western Oregon tribes, in particular, Southwestern Oregon tribes, say absolutely not. That is not historically accurate, and you did not have a presence here. Well, who's going to make the call, right? And the one thing I tell people is, it is absolutely not going to be me. I'm not going to be the one that's going to resolve those disputes. So I always encourage people to exercise caution when reaching out beyond those 9. Now, I'm going to also go back to, because it's required by law and because it's the right thing to do, I think that it is worth discussion, and it's an agency discussion, and perhaps even, executive level discussion about how you reach out to those other tribes to make sure that their voices are heard as well and incorporated. And I think if you can find a way to have those conversations with those other non-federally recognized tribes that allows their input to be received, but makes it clear that you're not asking for consultation, right? You're not asking for that government to government level interaction. If you can figure out how to navigate that, there's no problem with that, right? It's just doing the best you can to be respectful of everyone who was here before, regardless of their current designation or status. But I think I've had conversations with Roxy on that very issue, and what she told you is definitely consistent with the conversations that we've had in the past. So I recognize we're at 4:30. I recognize we're at 4:30 on a Friday afternoon, and I recognize it's 4:30 on a sunny, beautiful Friday afternoon. So I am happy to take other questions. I am happy to let you all go. I am also happy to just re-extend that invitation. If you have any other further questions, please email me, please call, please reach out. I'm happy to continue the discussion in whatever way is most helpful for you. Again, recognizing the scope of the participants that we have here. So hopefully this was helpful, and hopefully it's just the start of the conversation.
Thank you.
Thank you.
Thank you so much.
Great.
Thank you.
I just want to say that we're
It was
posting.
wonderful.
I just want to say that we are posting a link in the chat to a short survey about this session, and that will also help us improve future PMUG experiences. You can look forward to a follow-up email with links to resources, and please share with your team members and those who may not be on the listserv to reach out to be added. There's a link to the email in the message as well, right there. So Patrick, I want to say thank you so much. This has been super informative. It's just rare that we have something just, there's just so much information that was in there. And I just want to thank you so much on behalf of the team for being here today. So thank you so much.
My pleasure. Thank you.
And the final things that if you're interested in becoming an OPMAB member, visit the and if you're interested in becoming a PMUG planning team member, which is what I do and what Amy and Oh, and I'm sorry, I'm having a brain freeze. Does then let us know that as well. Again, if you're interested in learning more about business analyst process or participating in the BA&G planning team, visit the website that we posted earlier and enjoy your weekend. And we will convene again in July.